When cross-examining a witness at trial, does it help matters if I actually get into a verbal sparring argument with the witness? Will it help my case if I actually argue and start to yell and scream at the witness? Would you like to learn the answer? Come join me for a walk around the neighborhood as I tell you and share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The short answer is, no, it's not going to help. Jurors typically do not like when an attorney argues with a witness. And this becomes even more problematic when the witness is very sympathetic, when the witness is appearing as the nicest, sweetest person. Let's say an 80-year-old woman. And now she's like the typical grandmother, your grandma. And now, could you imagine if you start arguing and yelling and screaming at her? How do you think the jurors are going to react when you now go ahead and try and attack her credibility because of the fact that you think that she's wrong? I'll tell you how. They're going to turn against you. The jurors are going to turn against you and they're going to hate you. They're going to hate you as the attorney regardless of how good your client's case is. Why? Number one, because you're not being respectful to the witness. It doesn't matter which witness is on the witness stand. It doesn't matter what kind of attitude they have. There are instances where the witness is a lying piece of, well, you know what I'm talking about. And then you know what? I don't have to show the jury that he's a lying piece of. Instead, the jurors are going to know that. If I now get into a verbal sparring match with the witness, what am I doing? I'm now pitting my credibility against this witness's credibility. And it may become so bad, this argument may become so heated, that guess what? That the jurors may actually feel bad for the witness. They may actually start to feel sympathy for the fact that I'm beating up on this witness and trying to destroy him. In that instance, what have I done? I basically shot myself in the foot, taking somebody who clearly had no more credibility, and now simply destroying my credibility in the process. So one way that I've found and I've seen excellent attorneys, very experienced attorneys, deal with witnesses who are so oppositional, who are so defiant to all the questions that are being asked. You say the sky is blue, they say no, it's red. They say it's 10 o'clock, they say no, it's 12 o'clock. Every single thing that you argue, they have a different opinion. A better approach would be something like this. Mr. Jones, before we get started, I have a simple set of instructions. I'm going to ask you a series of questions. Can you promise me that if you know the answer, you will tell us the answer to that question? Yes, of course. And can you promise me that if you don't know the answer to that question, you simply will say, I don't know the answer to that question? Can you do that? Yes, I can. And if you're unsure about the answer to a question, do you agree to tell me that you're unsure? Yes. And if for whatever reason you cannot answer my question the way I ask it, do you promise to tell me, I'm sorry, I can't answer the question the way you have phrased it? Can you do that? Yes. Now, if I ask you any one of those questions, and I don't ask you for any additional information, do you promise to answer only the question that I'm asking about? Why, yes, of course. The witness is still trying to appear reasonable, even if he isn't, and even if he's going to do everything possible in just a few moments to show that he really is not reasonable. The purpose of laying these ground rules is that the moment he now steps out of line and starts to give me answers that deviate from exactly what I'm asking, now I have a chance to pounce. And now it's no longer a question of me trying to argue with him, but simply the fact that he has refused to follow my rules. So let me give you an example. Dr. Jones, isn't it true that on January 1st you saw my client in your office? Yes, that's true. And isn't it true that on January 1st my client made a complaint of having a lump in her left breast? No, that's not true. Are you aware that Mrs. Jones has testified in this case? Yes, I am. Are you aware that she has testified that when she came to your office on January 1st, she made a complaint of having a lump in her left breast? No, I'm not aware of that. Did you review her pre-trial testimony, known as a deposition? Yes, I did. And did you see in that, when she was asked that question about what complaint she made on January 1st during that first visit to your office, she specifically said that she complained of having a lump in her left breast? Yes, I do recall that. Now let me ask you again, doctor. On January 1st, when my client came to you, did she go ahead and complain of having a lump in her left breast? Well, let me tell you what she really said. Excuse me, doctor. I asked you a very simple, straightforward question. Was there something about my question that you didn't understand? Well, no, I understood it. Very good. So let's go back to the question again, doctor. When my client presented to you on January 1st, did she make a complaint of having a lump in her left breast? Well, you don't understand. What she had to do, I understood. Hold on, doctor. I asked you a simple question. It simply calls for yes or no. Can you answer my question? Yes, I can answer the question. Very good, doctor. What is the answer to my question? Well, I can't answer the question in the way you said because... Hold on, doctor. Did I ask you for a because or why you couldn't answer the question? No. So let's get back to the instructions that I gave you before you started to answer my questions. You had agreed and promised that if you knew the answer, you'd tell me that. Isn't that true? Yes. And you agreed and promised that if you didn't know the answer, you would tell me that too, correct? Yes. And you also told me, doctor, that if you could not answer my question the way I phrased it, you would do everything you could to tell me that, correct? Yes. And that you would not provide any additional information unless I specifically asked for it. Isn't that true? Yes. So let's go back to the question that I asked a few moments ago. Isn't it true that on January 1st, my client presented to your office with a complaint of a lump in her left breast? So what have I done in this scenario? What I've done is I've taken the ground rules and now established for this witness exactly what I want him to answer. And I'm not telling him what to answer. I'm just giving him his options of what he should be answering in light of my question. If the doctor now starts to go ahead and start arguing with me about one of the questions or one of the answers, I'm going to keep going back to the original rules that he agreed to at the very beginning of my questioning during my cross-examination. And by doing that, what am I doing? Now, I'm not arguing with the witness. I'm not being unreasonable. I'm simply telling him, listen, doctor, you agreed to these ground rules. I just want you to stick to them. And now, the more he begins to argue and fight with me, now at least I keep coming back to the same ground rules over and over again. And guess what? In this instance, the jury will likely be siding in my favor. Why? Because the doctor is being unreasonable. The doctor is trying to do everything possible to explain away each one of his answers and not go ahead with the restrictions that he has previously agreed to. Now, all this falls apart if at the very beginning when I'm laying the ground rules, the doctor refuses to go ahead with these ground rules and refuses to accept them. That's a different story and a different topic and a different video. But in this scenario, this is one of the easiest and simplest ways to avoid getting into a drawn-out, protracted argument with a witness during cross-examination and then ultimately generate sympathy for the witness. So instead, you turn the tables on the witness, and now if he fails to follow these basic rules and instructions, these ground rules, guess what? I'm no longer the bad guy. The doctor is the one who's trying to avoid answering these questions, and he's trying to do everything possible to give long-winded explanations so that he doesn't get restricted to a simple yes, no, I don't know, or I can't answer the question. So why do I share this great information with you? I share it with you just to open your eyes to help you understand how these types of cases work in New York. You know, I recognize you're likely watching this because you wanted to join me on a walk around the neighborhood and see the beautiful scenery. I realize you're watching this because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you are thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.